I've been provided some questions to ask to Counsel, and they're going to provide their unique perspectives for you. And the questions start for our Crown, Janet. I guess the question that people are going to have is, why is it that the Crown is prosecuting these cases in British Columbia? You've heard from a number of people their concerns about these prosecutions. From your perspective, what is the reason for these prosecutions?
I asked David to ask me this question. This seminar is clearly geared towards anti-criminalization, and I don't mean to co-opt that discussion at all. That is obviously a very powerful public policy debate that's being engaged in our society, and it's a very important debate. But one of the reasons why we prosecute this is because the criminal law, particularly the law of assault and sexual assault, is about the protection of personal integrity. I think this debate really does come down to who is going to decide what risks a sexual partner is going to take. Is it the sexual partner who's not infected, or is it the person who is infected who's going to decide what risks are going to be taken? If you ask me, it's always going to be my choice what risks I accept. I will never make those decisions for anybody else. If I happen to be infected with a sexually transmittable disease, I would consider duty-bound to inform that person. So I think that's really where the debate comes down. I am a little cautious around all of this discussion and the assumptions that I've been hearing made that somehow criminalization reduces or undermines the effectiveness of prevention of the disease. I haven't seen those statistics. I haven't actually heard why that is. And we have, of course, had the Courier case since 1998. As has been pointed out, prosecutions have increased since then. Is there some empirical evidence that actually shows that reporting or detecting of the virus, testing of the virus, has actually been undermined? Now, with regard to another reason why we prosecute this is we are often only ever receiving cases that are the worst case scenarios. The case that I prosecuted was the case of Ndueo. And I think that he is on the level that I would be surprised if anyone would be against prosecuting this particular individual. His behavior was so heinous. The public health officials had intervened. They had counseled him about his obligations. In fact, they had counseled him repeatedly. We actually called 2 of the doctors that counseled him as some of our witnesses. And then he went on to have sex with multiple partners, infecting 3 out of the 7 women that we knew of. That kind of behavior, and it occurred over years, that kind of behavior was really heinous, and his sentence did ultimately reflect his behavior. So there are many cases that reflect that type of behavior, and I just have to say that's one of the reasons why we prosecute them. We're there to protect people's sexual integrity, which I say is enshrined in Section 7 of the Charter.
So, with respect to interpreting the significant risk test, then, in British Columbia, how do Crowns look at things like viral load, issues of some of the issues that Richard raised, or oral sex versus anal sex, these kinds of issues? How are Crown currently interpreting that significant risk test, and when are they looking at that issue?
Well, and it's a very good point. Medical evidence arising from the accused has to originate from the defense, and that's the Regina and Wright case, 2009 BC Court of Appeal decision. That evidence is really in the hands of the HIV positive person. And so we look at it when we're given it. The defense never have to give us anything until they choose to actually call evidence. They don't even have to give us notice of their intention to call experts until 30 days before trial. They then don't even have to tell us what the expert is going to say until the close of the Crown's case. It may be that some defense choose to provide us with the evidence earlier than that so that we can look at it, particularly if it's an undetectable viral load and that they're asserting use of condoms and things like that. But that is basically, we'll look at it when we get it. With regard to how we interpret significant risk, we are interpreting significant risk in accordance with the nature of the activities. I'm not aware of a case in British Columbia, and I stand to be corrected, but I'm not aware of a case in British Columbia where we're prosecuting oral sex. We have only, to my knowledge, ever prosecuted penile penetrative sex. So how we're actually are speaking with our experts, typically, at least the case I was involved in, I certainly did, and we ask, is there still a significant risk of transmission? How you interpret significant risk, it depends on how you interpret the deadliness of the disease. And We then go on and decide to lay charges when we feel we have a substantial likelihood of conviction.
And then in terms of the charges that Crown are approving, do you look at lesser potentially included charges like a simple assault rather than aggravated assault? Do you ever look at a reduced charge given the particular circumstances, or is it only aggravated assault, aggravated sexual assault that you would be pursuing as Crown?
The theory is that under Courier, that because we have the endangerment to life component, that is laid under aggravated assault or aggravated sexual assault. So those are the charges that we would look at laying. For example, in Ndueyo, to avoid the trauma to the complainants and having to testify at a second time, because there was 2 trials, unfortunately. The first trial was overturned by the BC Court of Appeal for legal reasons that have nothing to do with the discussion here today. But I would have actually seriously considered a plea to aggravated assault. But given the seriousness of his behavior, Mr. Ndueyo's behavior, I would never have considered going below the level of aggravated assault.
And one final question, what are the statistics for British Columbia? And we had a little discussion about this beforehand, but can you explain about how HIV prosecutions are or aren't tracked that you're aware of?
The HIV prosecutions, I was speaking with the legal director of policy in British Columbia just yesterday. When a case regarding HIV, when we're considering laying a charge, we must, and we may get into this discussion a little bit more later, but the Crown who's considering laying the charge must consult with our bosses, our Deputy Regional Crown Counsel or our Regional Crown Counsel. Those are our bosses within our regions. And then if we do lay charges, we must notify the Director of Legal Services who is in Victoria. I was speaking with our Director of Legal Services in Victoria, and or Director of Policy, and we were unaware of the statistics in British Columbia. If we were to look up the charges of aggravated sexual assault in our computer system, that is laid in any number of different cases. I was, for example, last week prosecuting a case of aggravated sexual assault, which was an aggravated assault of a child. She was wounded during the course of a sexual assault in the middle of the night. And so if we look up the terms aggravated sexual assault, we would come up with all of those cases that we prosecute under that heading, and then we would have to look up each individual case. I'm not aware of anybody within the Crown Prosecution Service in British Columbia actually tracking how many cases that we prosecute. I don't think it's very many based on what I understand. I've been prosecuting for 12 years now.
Okay, thanks. Jason, you've had a client that's been prosecuted for non-disclosure. You're at the Court of Appeal and Supreme Court, and you convinced the court that viral load was an issue to be considered. What issues do you see, what challenges do you see in defending people who have been charged with non-disclosure, and what advice might you have for defense counsel in the room in terms of similar cases?
In respect of the JAT case, I think the biggest difficulty that I had was with the sexual offense squad at the Vancouver Police Department, not being aware of the different factors that affect the rate of transmission of HIV. They weren't aware of the co-infection aspect. They weren't aware of even the term viral load, and they weren't aware that the rates of HIV transmission vary according to the type of sexual contact. So the problem there was compounded by disclosure of my client's identity in the course of the investigation. A lovely picture of him with holding a martini glass. He looked like quite the party boy, which didn't assist him at all. And when the file was transferred to the Crown with the report to Crown Counsel, no medical report had been obtained about the risk of transmission in his particular case. Charges were approved without any sense of what the risk of transmission might look like, and no expert report was obtained by the Crown until approximately 8 months after the charges had been laid. Now, I appreciate that since the JAT case was tried, and we fought it hard, we moved to quash the committal to trial to try to afford him at least a little bit of privacy. We took the dismissal of our application to quash to the BC Court of Appeal, and took an appeal of that, or made application for leave to appeal to the Supreme Court of Canada, and we were dismissed on that application. all before we went to trial. That, I think, on some level assisted in bringing some notoriety to the case and its issues within the Crown office. And I think the Crown probably took some cues from that case. And as I understand it, the current policy is to obtain a medical report prior to charge approval.
Not that I'm aware of. It certainly is good practice, but it's not a
Sorry,
policy.
can you pass the mic over?
Sorry. It's not a policy. It certainly would be good practice, but it's not a policy. It was something that I would do.
So another one of the problems is inconsistent policy application within the Crown office. And part of the difficulty as well, I suppose, overall, just in dealing with the law as a human process, people have an awful hard time thinking about death. They have a hard time thinking about illness. They have a hard time thinking about sexual betrayal. And when you take all of those together in a single case, people bring all sorts of facts, assumptions, and values to the table. When you compound those general problems with the prejudice and bias against people with HIV, the associations to men having sex with men, the associations to IV drug use, especially illicit IV drug use, we end up with a kind of social context where it's difficult to talk to people about the most rational, fair, legal approach to take. Aside from the JAT case, I've represented a number of other individuals who've been facing investigations. And I have to say that the Vancouver Police Department's practices have improved, and at least at 222 Main Street, I've had very good dealings, very civilized and rational dealings with Crown Counsel dealing with the charge approval question. They've been receptive to receiving medical reports of viral load and expert reports of the significance of viral load. And in two of the cases I dealt with, charges were not approved for in no viral load contexts or no detectable viral load context. So the good news is that things are improving. The bad news is that the Courier case doesn't make sense anymore because I think it was decided in 1998 at a time when the real question was, is the person aware of their status? And did they fail to disclose their status? And just status triggered those two things. Now, the question is much more complicated than status. Just because somebody has an HIV positive status doesn't mean they can necessarily transmit. Just because they know their status doesn't mean that they're aware of the risk of transmission. So because these cases are built around a kind of fraud apparatus where you have to have a falsehood and you have to have a knowing statement of a falsehood, you kind of lose the simplistic analysis you had in Courier. And it'll be for the Supreme Court of Canada to resolve that, but things are not as simple as they once were, and it may just, it could go either way. Supreme Court of Canada could make it easier to prosecute or harder to prosecute, but it just seems on the facts here, with the new medical nuances, it's just harder to make out a fraud.